Hi, this is Dan Smith of DPS Legal Counsel, and today I'm going to be talking about choosing the right form for you of legal entity to operate your medical practice. There are essentially just a handful of possibilities. You can either operate without any legal entity at all, in which case if it's just one person, that would be a sole proprietorship. If there's more than one person, like 2 doctors, 3 doctors, whatever, operating together in a group, then that would be a partnership. That's one option, which we'll talk about in a minute. The second option is to set up either a corporation or an LLC as a separate legal entity to operate your practice. So, broad brush, the 2 main categories of options would be do nothing and operate either as a sole proprietorship if there's just one of you, or a partnership if there are more of you, or set up a legal entity which can be either a corporation or an LLC. And then within that category you can choose to elect S status or S corporation status for either your corporation or your LLC. But that's getting a little bit into tax planning. We'll talk about that briefly, but not in great detail today. Now, let's go back to choosing or at least considering not setting up any legal entity at all for your practice and just operating either as a proprietorship if it's just one doctor, or as a partnership if it's a group of doctors. Bottom line, if there's more than one doctor operating in the practice, if you have a group, if there are 2 doctors, 3 doctors, 100 doctors, anything more than one, it would be probably a big mistake to operate as a partnership without setting up a separate legal entity. The main reason is you don't want to be liable for the malpractice of your partners. And if you operate as a general partnership, whether there are 2 of you or there are 10 of you or 100 of you, if one of your partners commits malpractice and you don't have a separate legal entity, you are going to be responsible financially, at least theoretically, for the malpractice of your partner. And so the main reason that people operating in a multi-member or multi-owner practice set up a legal entity is for liability protection. And that is a good reason to set up a legal entity. If there's more than one of you, set up a legal entity for sure, either a corporation or an LLC. We'll talk in a minute about the differences between the 2 and which one you might choose. If you're going to be practicing by yourself, just one doctor, you may want to choose to operate without a separate legal entity. Now, you don't have liability protection of a corporation or an LLC. That's true. But here's the thing. An LLC or a corporation does not provide liability protection to a doctor or to any other licensed person like an accountant or a lawyer who operates either in a corporate or LLC form for their own professional negligence or malpractice. So, stated another way, if you operate your practice as an LLC and you commit malpractice, the LLC does not protect you or give you limited liability from your own professional negligence or malpractice. That's why you have malpractice insurance. If you operate as a corporation and you commit malpractice, the corporation does not protect you or give you limited liability from your own malpractice or negligence. That's why you have the insurance. So, what it does protect you for, a corporate form or an LLC form, is non-professional negligence and contract issues that could be of importance to your practice. For example, if someone comes into your practice, your waiting room, and slips and falls on a banana and breaks an arm and sues the practice, if you haven't incorporated or set up an LLC for your practice, they would be suing you individually and personally, and your own personal assets would be at risk in that instance. The same thing with a contract. You would get sued personally for an alleged breach of contract, whereas the entity itself would get sued under that contract if it is the party that entered into the contract. Now, you have to make sure that if you do set up a separate legal entity, that you don't undercut the liability protection that it provides for contract issues, like, for example, leases, by personally guaranteeing that contract or that lease. If you do that, then the protection that it provides for that particular risk goes away. So let's recap where we are right now. If you have more than one doctor, definitely set up a PC or a corporation, professional corporation, or a PLLC or professional limited liability company. You want to have a separate legal entity in place if there's more than one of you practicing together. If it's just you, you can make a decision. Do you want to go through the time and expense, and it's not much, of setting up a separate legal entity in order to have the liability protection that it affords to you for non-professional liability, professional negligence, and for contract issues? I would say in most cases, for most doctors, the answer would be that yes, they do want to set up a separate legal entity even if they are practicing alone, simply to provide the liability protection for contract issues and for non-professional negligence issues like slip and fall in your office. Again, make sure that if you do that, that you don't undercut your own liability by personally guaranteeing contracts to the extent that you can avoid doing that. Now, if let's say that you have decided to set up a separate legal entity, even though you're just in practice by yourself, or there's a group of you, and you definitely are going to be setting up a separate legal entity. Which one do you choose, corporation or an LLC? Well, essentially they provide exactly the same liability protection. Exactly the same liability protection. So there's no difference. LLCs are simpler and less burdensome to create and to manage. And so for most people, an LLC is going to be preferable to a corporation, just from the ease of administration alone. And so that's probably going to be the choice of the entity of choice for most doctors. Now, you need to walk through all your circumstances, obviously, with your own advisor to talk about what you're looking for in an entity and what the pros and cons are for various entities, especially in another state. I'm only talking about Tennessee because that's where I'm licensed to practice. But if you you have that choice to make. So let's say you've chosen to go with an LLC because it's the one that's typically used more often than not these days. Are there any other choices to make at that point? Well, the final choice you could make is you could choose to either have that LLC operate as under its default tax structure, which is if there's only one of you, it's a total pass-through entity to you. It's a disregarded entity is the term of art for in the tax world for what it is to you. The monies would flow through just like it was not there for tax purposes and show up on your on a Schedule C to your 1040. If there are two of you or more than one of you, 3, 4, 5, whatever, the default federal tax treatment for an LLC is a partnership. And so you have the limited liability protection of an LLC, but you have the tax treatment of a partnership. It's great. Monies flow through in allocable shares to the partners and show up based on K-1s that each of the partners get at tax time. Or you can choose to elect S corporation status for your LLC. If you do that, then instead of the default tax treatment, which is disregarded entity for a sole owner and partnership for more than one owner, the tax treatment would be, if you make the S election, that it would be taxed as an S corporation, even though it's an LLC. In which case, it's still a pass-through entity, but it would have to file its own federal tax return as a reporting tax return, which is an 1120S. Funds would still flow through to the owner or owners in allocable shares. And one benefit that an S corporation has over other entities is that you can sometimes save self-employment tax by not paying all the income, or all the income that would flow through as comp to the owners as comp. In other words, if you are a W-2 employee of your S corporation and you have $100,000 to distribute, then you could only distribute some portion of that, and the rest would be considered a dividend. And you don't pay self-employment tax on dividends, only on W-2 income. Now, there are limitations on how you can use that to your tax advantage, because you have to be able to pay a reasonable salary to your employees, including yourself. So you can't just pay yourself $1 and then have the rest of it flow through as a dividend. In order to not pay the self-employment tax. That would be not only would that be an illegal tax maneuver and get you in trouble, but it just would not work. You can't do that. So if you're going to set up an S corporation or elect to have an S corporation status for your LLC, you definitely want to talk to your tax advisor to talk about tax planning for how much wages to pay and how much of what would otherwise be comp can effectively be treated as a dividend without causing a tax problem. Again, that gets into a little more complexity than what we want to talk about today. Today we're just talking about which entity should you choose and why. And so to recap and to go back, I would say if you are a sole owner of your practice, just one doctor, you can legitimately choose to do nothing and just have no legal entity if you're not concerned about liability issues. If you are, then choose to set up a legal entity. And that would be my general recommendation for most doctors, is to set up a legal entity. And the entity of choice, in most cases, at least for me, would be an LLC. Then whether you choose to have an S status election for your LLC depends on your tax situation. That requires a lot more discussion to see if that makes sense for you. If you have more than one doctor practicing, by all means, set up a separate legal entity. And again, I would pick an LLC and then go into the analysis about whether it should be an S corporation or not. Okay, that's a lot of information. I hope that helps, and we'll see you again next time.